Everybody, News Now Wyoming here once again, looking at the Jack Miller versus Stupid Cops. And in this document, I know I am a month late here, adding the city of San Angelo. Oh, how cool. If you recall from the very first time I looked at the lawsuit, I said that I think this case would survive a Monell ruling. And so it is awesome to see that San Angelo has been added to the case. Now, if you go through the docket itself, they actually there was another extension of time for responses. Still pending before the court is, does qualified immunity even follow? Again, I don't think it does. We will have to wait and see. But all right, let me move around this mic a little bit. Let me play with that. What does that look like, huh? All right, so first amended complaint. Okay, we've already gone through most of it. We'll ignore. Sergeant Holt admitted there had been confusion regarding the crime of failure to identify as long as he had been with San Angelo Police Department. Sergeant Holt then admitting that he has seen people get charged for failure to identify in consensual contacts despite this being illegal. He has been with the police department since 1998, over 20 years. This means that they've been illegally arresting people for failing to identify themselves despite no authority requiring that they do so for over 20 years. Also files this, so this is the new stuff. Files this lawsuit against San Angelo, Texas for maintaining an unconstitutional practice of arresting people without probable cause and for maintaining unconstitutional training policies regarding when and who could be arrested for the offense of failure to identify, which led to the violation of its constitutional right. Okay, so we got Mr. Jack Miller, and then stupid cop, stupid cop, stupid cop, then the city. Served through its city manager, blah, blah, blah. Okay, so we're going to skip this. Again, we've covered this. I do have another video. If I knew how to do the thing up above, I would do that, but I don't. So, I have covered this case in detail, going over every file, including this document, and I'm just looking to see if there's, just browsing it, see if anything new has been added here, and I don't see anything. Called him a dumbass. Yeah, alright. On December 1st, 2020, detective called Mayberry and asked him if he completed a use of force report on the incident. Advised he had not because he did not do anything but put cuffs on him. He informed Mayberry that he should go watch the video because there were some things that would require a report. This demonstrates that Detective Black believed there was more force used than Defendant Mayberry was admitting. Ooh, this is new. I don't remember reading this. On December 1st, Detective Black called Defendant Weber and asked him if he completed a use of force report. Defendant Weber advised he did not write one. Defendant Weber advised he did not do anything to cause pain like wrist locks. Defendant Weber said all they did was hold on to him till they could get him handcuffs. That he should watch his video and do a report. Now, oh my God, I have a problem with this, just for the simple fact that the detective is requesting the officers to review the video footage before they file a report that requires perjury. I have a problem with that, you guys. I do. And let me tell you why. And this microphone still feels so far away from me. Hold on. Is that any better? Or is that going to be too soft? All right. I have a problem with this. Cops want to talk to me and they want me to write out a report. They want me to answer their questions. They're not going to let me review video evidence before I write that, are they? Are they really going to allow that? Is that something that they do? So why do cops get this treatment? Just like if I'm involved in a shooting, if somebody breaks into my home and I shoot somebody, and I will, by the way, no question about it. Somebody breaks in here, they're getting shot dead. Alright, now that that's out of the way, if that happens, cops are going to demand I talk to them right now. Otherwise, I go to jail. Why is it the cops around this country are advised and told not to answer any questions or talk about the incident after they've been involved in a cop-related shooting for at least 24 hours? Why do they get more rights than I do? Why do they get that presumption of innocence and not go to jail? Whereas if I refuse to answer a question, I'm going to jail until they figure out if I did anything wrong. Why don't the cops get the same treatment? Okay, but anyway, you guys, that's off the topic here. Detective Black advised that he should watch his video and do a report. Big problem with that. They walked the handcuffed Mr. Miller out of Walmart into a police car. DM was scared while he was forced to wait inside the Walmart with Defendant Weber after just having watched Defendant Weber assault his father. He was placed in the back of a handcar of a police car. The officer arrived and Mr. Miller explained to him that he had been arrested for failing to identify himself. He asked defendants what happened and they told him they did not have probable cause that Mr. Miller had committed any crime. He told them to release Mr. Miller. This actually cuts stuff out, and this the previous lawsuit actually went into it more. The previous complaint I thought had more in there because what you actually see in the video is during this discussion. So between 87 and 90, you see Sergeant Holt trying to come up with some way to save this before actually tell him to get off. Let the guy go. Let Jack go. You see that. You see that continuously. He's like, oh my God, what can we do? How can we cover our asses here? Because this is going to be bad. But they left it out of this, but that's alright. Okay, so failure to train officers on the law resulted in constitutional violations. Following the false arrest of Mr. Miller, Sergeant Holt told defendants that it happens. Upon information and belief, Sergeant Holt was stating that false arrest for failure to identify happened. He then stated there had been confusion regarding failure to identify as long as he had been at the San Angelo Police Department. Sergeant Holt stated that he has seen people get charged for failure to identify on consensual contacts with police officers. A consensual contact involves no form of detainment or even possible suspicion, let alone probable cause that a crime has been committed, is being committed, or is going to be committed. During the internal investigation into this incident, Defendant Francis stated that when they were attempting to get Mr. Miller to identify himself, he was treating the interaction with Mr. Miller as a consensual contact. During the internal investigation into this incident, Defendant Mayberry stated that the interaction with Mr. Miller was a consensual contact. During the internal investigation into this incident, Defendant Weber stated he believed the interaction was a detention. Ooh. None of the officers believed Mr. Miller was under arrest at the time he refused to identify himself. The fact that San Angelo police officers have initiated a consensual encounter with the citizen, asked for their identification, and then arrested them and had them charged with the crime for failure to provide their identification during the consensual encounter is beyond frightening and is directly attributable to San Angelo and Defendant Chief of Police Frank Carter's failure to train and supervise its officers. And that right there is why I believe it may just survive the Monell claim. This is my first time actually reviewing this document, but I said that from day one of this case, that this city should have been included in this. The fact there had been confusion regarding failure to identify as long as Sergeant Holt had been at the San Angelo Police Department shows that this was not simply stupid defendants not knowing the law, but it was a department-wide issue stemming from the inadequate training being given to San Angelo police officers. The fact that Sergeant Holt has seen people get charged for failure to identify shows that this was not simply a one-off issue with stupid cops. Excuse me, dry throat. But that it was a department-wide issue stemming from the inadequate training being given to stupid police officers. During an internal investigation into this incident, stupid defendant stated that it was his understanding of the law that if somebody was being detained, they could not refuse to give their name. He said that if it was a legal detention, the person had to identify themselves. Sergeant Travis Griffith corrected stupid defendant on the law and explained that a person had to be arrested to force them to give their name. He continued to be confused over the specifics of the law. So what you need to do, you guys, if you have not, go over to Not Texas Sheepdog and watch the videos. Watch these interviews. Oh my God, that big fat cop, biggest idiot on the planet. Even when they plainly spell it out for him, he's still like, what color is purple? Really, you guys. I mean, all the way. All right. He was stupid. I mean, just watching the guy, it's like, and that's Sir Blinks a lot. If you don't know who Fatso is, that's Sir Blinks a lot. That's that. I believe he was a corps or two stripes, whatever two stripes is. Corporal. He was a two striper, and Sir Blinks a lot. Every conversation was like, yep. That was him. Okay, Fatty. Sir Blinks a lot. All right. During the internal investigation into this incident, stupid Weber agreed with Detective Rodney Black when Detective Black stated that he believed Defendant Weber thought if someone was being detained, they had to identify themselves. In a letter from Defendant Clark to Defendant Francis regarding the false arrest of Mr. Miller, Defendant Clark stated clearly the suspect was not under arrest at the time he refused to identify himself to you, and as a result, your actions to arrest him for a violation of 3802 was a misapplication of law resulting in an unlawful arrest of the suspect. Why would Defendant Clark write to Defendant Francis? And this is the cop again. If you go watch those videos, the third cop involved, the one that came in late, he was throwing the other two stupid cops completely under the bus. I mean, yeah, I don't understand why he... Well, no, I do. He wants to provide himself backup there, man. He really threw everybody else under the bus. So he put it in writing, telling one of the other defendants that you screwed up. Wow. Following the internal investigation into this incident, Detective Black concluded that stupid defendant's misunderstanding of the failure to identify statute led to an unlawful seizure of Mr. Miller by placing him under arrest, and their misunderstanding of the failure to identify statute led to the unlawful seizure. And this has all happened since the lawsuit was filed, which is also probably why city was just added. The internal investigation found this following this arrest, sustained knowledge of law's allegations against defendants. Defendant Carter required a mandatory department-wide training. So the police chief required a mandatory department-wide training related to the application of 3802, failure to identify. It is clear that San Angelo and Defendant Clark's failure to adequately... Defendant Clark. Okay. So Defendant Clark is not the one that was interviewed. Defendant Clark must be... Okay, I'm on page 16. Let's go back up here. Who else was added? Police chief? I don't know who that might they call him a defendant here, but he's suing the city, not the department. And that wasn't the city manager's name. Who's the defendant Clark? Did I miss it? What was the police chief's name? Carter, who is also not named above. Okay, I don't know who Carter or Clark are. I'm thinking police chief. Hold on. Carter is the police chief, so who's Clark? You guys, I just went through all the Clarks, and he never actually says who Mr. Clark is. That may be a problem, but probably not. They can fix that. Okay. To adequately train San Angelo police officers on when it is appropriate to arrest someone for violating 3082 led to the constitutional violations in this case, based off of Sergeant Holt told them that it happens. In fact, there's been confusion regarding failure to identify as long as Sergeant Holt had been at the San Angelo Police Department. Sergeant Holt's witnessing multiple people being arrested and charged for failing to identify during consensual encounters. Stupid defendants, all not knowing and correctly applying the law at the time of his false arrest. Yeah, again, defendant Clark. And the fact that the chief of police required a mandatory department-wide training relating to the application of failure to identify. Upon information and belief, discovery into information within the knowledge of the city will show that there are more instances of people being arrested for failure to identify, despite San Angelo police officers not having probable cause that these arrests violated the failure to identify law. Count 1, unlawful arrest. Excessive force for hurting him. Big time. Practicing customer of deliberate indifference. Monell. So this is the Monell claim, okay? Plaintiffs repeat and reallege each and every allegation contained in the above paragraphs as if it fully repeated herein. Municipalities, including counties and cities, may be held liable under 1983. Municipality may be liable under 1983 if the execution of one of its customs or policies derives a plaintiff of his or her constitutional rights. Municipal liability may attach where the constitutional deprivation is pursuant to a governmental custom, even if such custom has not received formal approval. Under the decisions of the Supreme Court and the Fifth Circuit, municipal liability under 1983 requires proof of three elements: a policymaker, an official policy, and a violation of constitutional rights whose moving force is a policy or custom. The plaintiff may demonstrate a persistent, widespread practice of city officials or employees, which, although not authorized by officially adopted and promulgated policy, is so common and well settled as to constitute a custom that fairly represents municipal policy. And again, I'll say this. There's no way in hell that this case ever makes it to a jury, you guys. No way. It's going to be settled. As soon as they resolve the rest of these early issues, this is going to be settled. Municipality cannot be liable for an unwritten custom unless actual or constructive knowledge of such custom is attributable to a city policymaker. To establish municipal liability under 1983 based on alleged persistent, widespread practice or custom that is so common it could be said to represent municipal policy. Actual or constructive knowledge of such practice or custom must be shown. Constructive knowledge may be attributed to the governing body on the ground that it would have known of the violations if it properly exercised its responsibilities. Where the city council and the police chief, because the specific identity of the policymaker is a legal question that need not be pled. Plaintiffs can state a claim for municipal liability as long as they plead sufficient facts to allow the court to reasonably infer the board either adopted a policy that caused ML's injury or delegated to a subordinate officer the authority to adopt such a policy. In other words, plaintiffs must plead facts that sufficiently connect the policymaker to the alleged unconstitutional policy. Here, the city council is a policymaker for the city of San Angelo, who is responsible for the policies of the San Angelo Police Department. City council had constructive knowledge of the city's customs, practices, and effective policies regarding arresting people without probable cause. The crime of failure to identify had been committed, and failing to adequately train officers on when someone can be arrested for the crime of failure to identify, as they would have known of the violations if they would have properly exercised their responsibilities. Over 20 years, as referenced by Sergeant Holt. Alternatively, the city council is policymaker for the city, delegated policy-making authority to promulgate, adopt, approve, or ratify the de facto policies regarding arresting people without probable cause and failing to adequately train officers on when someone can be arrested for the crime of failure to identify to the police chief deputy for the San Angelo. Oh, so is Clark the deputy? And Carter is the deputy or the police chief? Okay. City, under the direct supervision of the city's policymakers, the city council and chief of police maintained, implemented, encouraged, and ratified the following unconstitutional practices and policies, with deliberate indifference to the constitutional violations they were directly causing and would continue to directly cause, such as the illegal arrest of Mr. Miller by stupid defendants. Okay, we've already heard all that crap. City's failure to train. To plead a plausible failure to train claim, a plaintiff must allege sufficient facts to show the training procedures were inadequate, the city's policymaker was deliberately indifferent in adopting the training policy, and the inadequate training policy directly caused the plaintiff's injury. I would say yes to all of that, right? Because obviously these three stupid cops didn't know any better. And Fatso, or Sir Blinks a lot, he really had a hard time understanding it, even when they spelled it out for him. And they said, okay, go ahead and repeat back what the rules are. And he goes, well, if I detain somebody, then If I detain somebody, then I can arrest them if they failure to ID. And the detective, he just kind of goes, no. And then he repeats it again, the law. So Sir Blinks a lot should not be on the streets ever again. I'm sorry. If you're too stupid to be trained, you shouldn't be on the streets. Oh, we're approaching 30 minutes here. No more talking about Sir Blinks a lot. Despite knowing that this lack of training will result in unconstitutional illegal arrests, such as Mr. Miller's in this case and the previous arrest referred to by Sergeant Holt. Supporting Monell claims. It happens. Yeah, they're going to repeat the investigation again. False imprisonment. False imprisonment. Cool. Yep. I don't think that's new. Assault. Pressing him against the cooler, going, ah, and then choking him with the cooler, right? Yep, choking him. Raising his arm so he was handcuffed, and they pulled his arms up. That would hurt by anybody's standards. Bystander recovery. This is their weakest count, but that's alright. It's a state count. Punitive damages. When viewed objectively from the standpoint of defendant Weber, Mayberry, and Francis at the time of this occurrence, said defendant's conduct involved an extreme degree of risk, considering the probability and magnitude of the potential harm to others. As a direct, proximate, and producing cause, and the intentional, egregious, malicious conduct by defendants Weber, Mayberry, and Francis, which was recklessly or callously indifferent to Miller's and DM's protected rights, see individually and on behalf of DM, is entitled to recover punitive damages. Mayor cut. Okay. Attorney's fees. And there we go, you guys. So, what do you guys think? Jack Miller versus stupid cops and the city of San Angelo. Will this survive a Monell claim? Will this even survive the first hurdle of qualified immunity? I still think that they have no chance at all in winning qualified immunity on this case. But the fact that the judge actually required real arguments against it says just how stupid this judge actually is. And even if this judge dismisses it, it's going to be one on appeal and sent back down. But with this, we'll see. We have to see what this judge does. I do not want to impugn this judge without good reason, because that's not what we do on this channel. Alright, you guys, so there we have it. Let me know what you think. The next response is due at the end of this month. This was a second continuance on that response. I imagine that it was granted because of this First Amendment complaint. So the judge said they could have more time. Don't see an issue with that. So the end of August will be the response. So hopefully we finally get that response in our hands. All right, you guys, have a great day, and I'll talk to you later.